So let's add some more building blocks. Okay, so notice of constitutional question module, high-do focused, but reusable. Draft order language, a judge could actually sign. Okay, so notice of constitutional question between Aaron Michael O'Neill, applicant, and Attorney General of Canada, respondent. Notice of constitutional question to the Attorney General of Canada and to the Attorney Generals of each province and territory of Canada as required. Take notice that the applicant, Mr. O'Neill, intends to raise constitutional questions in this application for judicial review concerning the failure and refusal of the Minister of Employment, Workforce Development and Labor, then the Honorable Patty Hajdu, and associated federal decision makers to reasonably respond to the applicant's 2018 homelessness risk notices regarding his Canadian student loan, and the operation and application of federal student financial assistance and collection schemes, including the Canadian Student Financial Assistance Act, its regulations, and the related RAP-PD hardship and collections policies insofar as they permit the transfer of a disabled borrower's loan to CRA collections and the denial of stabilizing measures despite known risk to life, health, and equality. The applicant says that these failures and statutory applications infringe his rights under Section 7 and 15 of the Canadian Charter of Rights and Freedoms by depriving him of life, liberty, and security of the person and by denying him equal benefit and protection of the law as a disabled, precariously housed, Indigenous descendant borrower, and the court must grant effective remedies under Section 24(1) of the Charter and exercise its powers under Sections 18 and 18.1 of the Federal Courts Act in a manner consistent with the Charter. Without limiting the generality of the foregoing, the constitutional questions include whether it is consistent with Section 7 and 15 of the Charter for federal student loans and collection schemes to authorize or permit the transfer of a disabled borrower's loan to CRA collections despite actual notice of imminent homelessness and lack of safety net, the refusal of a mission to conduct any meaningful hardship review or to coordinate homelessness prevention supports, and the treatment of such a person as a routine collections file rather than as an individual whose life, security, and equality are at stake. Whether the minister's non-decision and ongoing omission in response to applicant's 2018 homelessness risk notices constitutes a charter inconsistent exercise of statutory discretion under the Federal Courts Act and the relevant student assistance legislation. What remedies are required under Section 24(1) of the Charter to cure these infringements, including but not limited to declaration of breach, orders quashing or setting aside the October 16, 2018 ESDC non-decision, mandamus directing a fresh charter-compliant determination of the applicant's file, and structural interpretive orders ensuring that homelessness risk and disability-based hardships are treated as primary considerations in future administration of these schemes. The material facts giving rise of these questions are set out in the applicant's Notice of Application Form 301 O'Neill and Affidavit of Aaron Michael O'Neill, including the applicant's September 17, 2018 email to the Prime Minister's office regarding crippling student debt and homelessness risk. The PMO's forwarding of that email to the Honorable Patty Hajdu as Minister of Employment, Workforce Development and Labor, the applicant's October 1st, 2018 email directly to Minister Hajdu, the October 16, 2018 ESDC form letter response advising that his loan has been transferred to CRA collections and offering only rehabilitation payments. The November 16, 2018 letter from Crown Indigenous Relations forwarding his correspondence back to Minister Hajdu as the minister's best able to help, and the cascading harms of homelessness, health deterioration, and long-term disability documented in the WSIB and medical evidence. The constitutional provisions at issue are Section 715 and 24(1) of the Canadian Charter of Rights and Freedoms. The statutory and regulatory provisions at issue include the Canadian Student Financial Assistance Act and regulations, the Federal Courts Act, including Section 18 and 18.1, associated ESDC and CRA student loan collections policies, RAP and PD guidelines, and hardship compassionate consideration frameworks as applied to the applicant. The hearing of this application is proposed to take place at Ottawa, Ontario via telecommunications or video as a date to be fixed by the courts. Draft order. Upon the application of the applicant, Aaron Michael O'Neill, for judicial review pursuant to Sections 18 and 18.1 of the Federal Courts Act, and upon reading the notice of application, the affidavit of Aaron Michael O'Neill and exhibits, the applicant's memorandum of fact and law, the respondent's material if and having any heard submissions, and upon being satisfied that the Minister of Employment, Workforce Development and Labor through Employment and Social Development Canada failed to reasonably and fairly respond to the applicant's 2018 homelessness risk notices and thereby infringes rights under Section 7 and 15 of the Canadian Charter of Rights and Freedoms. It is hereby ordered that the application is allowed. The letter dated October 16, 2018, issued by ESDC on behalf of the Ministry of Employment, Workforce Development, and Labor, purporting to address the applicant's Canada student loan and related concerns, is set aside as an unreasonable and procedurally unfair decision or non-decision. The matter is remitted to a different, properly instructed decision maker within ESDC for redetermination with the following directions. The decision maker shall treat the applicant's homelessness risk, disability status, lack of family support, and cumulative trauma as primary considerations in exercise of discretion. The decision maker shall consider the applicant's rights to life security of the person and inequality under Section 715 of the Charter. The decision maker shall consider the full range of available hardship, stabilization, and homelessness prevention tools, including but not limited to interest relief, payment suspension, write-down, write-offs, program transfers, referral to specialized supports, and coordination with other federal departments. No enforcement or collection action shall be taken against the applicant in relation to the federal student loan debt until a new decision has been rendered in accordance with this order. For greater certainty, any limitation period for bringing this applicant is extended nuns pro tunc, pursuant to Section 18.12 of the Federal Courts Act, having regard to the ongoing and rolling nature of the harm, the applicant's homelessness, health collapse, and the lack of legal representation, and the role of state actors in prolonging the conditions that impede timely litigation. It is declared that the Minister failures and omissions in responding to the applicant's 2018 homelessness risk notices breached the applicant's rights under the Section 7 and 15 of the Charter, and that future administration of the relevant federal student assistance and collection schemes must be interpreted and applied in a manner consistent with this declaration. It is further declared that in administering federal student loan and related social support programs affecting vulnerable and disabled persons, the Crown has a duty to ensure that homelessness risk and disability-based hardships are treated as central considerations, and that purely mechanical reliance on defaults in collections policies and circumstances is inconsistent with the Charter. The applicant should have his costs of this application payable to the respondent in event of the cause. There shall be no order as to costs, such further and other relief as the court deems just.